What's a girl to do when she's divorcing a Beatle and a bit down in the dumps in LA? A spot of retail therapy in Heather Mills's case. She was spotted in Hollywood this week after reportedly meeting with US lawyers, a move which could net her much more of Sir Paul's multi-million-pound assets. Paul famously didn't sign a prenuptial 4 years ago, as he said it was unromantic. But if they don't resolve things amicably, lawyers say that could be a very expensive decision.
Joining us now from Los Angeles is celebrity divorce lawyer Peter Lauzon. Peter, very good to see you. Thanks very much for staying up to talk to us. Help me out here. Can people who are resident here in the UK nevertheless file for divorce in the United States?
Well, first of all, good morning, John. Yeah, if they are residents in the UK and if they maintain a residence here in California, or residence here in California, they can certainly attempt to file here in California. The question remains whether or not that particular action will be maintained further down the road here in California. In order to file a divorce action in California, you have to establish jurisdiction, and jurisdiction is established by residence. You have to be a resident of California for at least 6 months prior to the filing of the petition. And not only that, you have to demonstrate an intent to remain in the state of California. So what Ms. Mills will have to do is to demonstrate to the courts that she is living in California and intends to remain in California.
He has already filed for divorce here in London. It could get quite messy, couldn't it?
Absolutely, and fairly typically the courts, at least the courts here in California, will look to the fact of the first person to file. So Sir Paul filed first in England, from what I understand. The courts will look to that. The next step in the analysis is if Ms. Mills were able to get over the residency requirements. Sir Paul's lawyers, I anticipate, will argue that the forum is more convenient in England, which happened to in the Mick Jagger case in 1979. Although residency was established here in California, it became more convenient and is more convenient to litigate the action in England because the residents are there, the businesses are there, the money is there, the parties happen to be there the majority of the time, and any number of other factors that the court may utilize.
Am I correct in assuming that it would be to her advantage to try and get this case heard in the United States, where settlements are likely to be more generous?
Well, in California, it's fairly typically understood that settlements are more generous, and that's understood throughout the United States. I'm not quite sure if that's understood throughout the world, but in California you generally have higher child support orders, you generally have higher spousal support orders. If Ms. Mills were successful in jumping over the hurdles of jurisdiction and forum nonconvenience, and a judge decided to have it heard here, she would stand to receive 50% or 1/2 of anything that Sir Paul acquired during the 4 years of marriage. On top of that, she would have a substantial child support order. Child support is based on the relative incomes of the parties. If Sir Paul has made a tremendous amount of income during the marriage, that child support will be tremendous. And also on top of that, she stands to receive spousal support, which would be based on the lifestyle of the parties. So yes, she has the opportunity to obtain a substantial award here in California.
That's all we've got time for, I'm afraid, right now. Kate and Andrew up next with GMTV Today.